Good morning, everybody. This is Chuck Whitford with JRG Advisors, and welcome to our webinar this morning, ERISA Compliance, focusing on disclosure. I'd like to announce that we have expanded our compliance team here at JRG, and so joining me today will be our ERISA attorney, Frances Horn.
Good morning, everyone.
We'd like to welcome our valued clients and partners to this webinar. There will be questions and an opportunity to ask questions at the end of the presentation, typing in your question, and we will do our best to answer them. If it's a technical question that we need to do a research on, we will get back to you on that. At the end, we will send out a summary of any questions and answers within a few days, and the PowerPoint. So looking at our agenda, as I mentioned, we're going to discuss the subject of disclosure, and including things like the employer obligations, the written document requirements, and most importantly, rights and penalties. Employers have been focusing lately on the Affordable Care Act for good reason, especially as 2016 is right around the corner. Many have forgotten or ignored their responsibilities under the Employee Retirement Income Security Act of 1974, commonly called ERISA. This was the first bill signed into law by President Ford on Labor Day in 1974, and many think that ERISA deals mainly with retirement plans, but health and welfare plans are also included and part of the focus of the law. So let's review the types of benefit programs that fall under ERISA. As you can see from this list, not only are group medical, life, and disability plans considered ERISA benefits, vacation and holiday and severance benefits, and others are included. But don't panic and think that you have to go out and get a plan document for your vacation plan. These are types of benefits that can be considered ERISA, but not necessarily are an ERISA plan. When I speak with employers, I find that many feel that ERISA applies only to large employers or only to for-profit employers. Actually, just about all employers fall under ERISA. You can see the two major exceptions are government entities and church plans. Some plans are exempted, either statutorily or regulatorily. Plans required by state law, plans that cover self-employed individuals, that cover no common law employees, foreign plans, along with certain payroll practices are exempt. Frances?
Thanks, Chuck. Well, after reviewing the benefits that you as an employer are providing to employees, based on the great information that Chuck just gave us, you can determine what benefits are subject to ERISA. Once you've determined whether ERISA applies to your health and welfare benefits, you need to understand what must be done to comply with ERISA. The main thing to remember about ERISA is that it was originally enacted to protect the rights and interests of the participants, generally employees and also beneficiaries. So one thing you always have to remember about ERISA, it's all about protecting employees or participants. Now, how this protection occurs is really through four main obligations that employers as plan sponsors have. And the first three bullets come under the disclosure requirement of ERISA. The plan sponsor or employer must disclose to participants their rights and obligations. And generally, this is done by the requirement that an employer must have a written plan document and an SPD, which Chuck is going to address in a couple of slides, and disclose or communicate this information and these documents to the participants. For those of you who must file Form 5500, if you're over 100 or more, which is a reporting requirement, you must also disclose plan financial information, what's called a summary annual report to the participants. Another obligation that ERISA imposes is the responsibility of fiduciary duties under an ERISA plan. Now, first of all, a fiduciary is the person who is ultimately responsible for the plan. So they, what we're going to do is at a later discussion or a later webinar, we are going to really go into depth on fiduciaries. So I just wanted to go ahead and mention it right now. However, the key responsibility of a fiduciary is to follow the terms of the plan. An employer must administer the plan according to its terms. So again, that tells you you have to have something in writing so you can follow it. Now the next two bullets we talk about are subpoints of the employer's four main obligations under ERISA, because these are additional disclosure requirements. So first of all, disclosure is also required by the employer when any of the terms of the plan change. So if you're changing co-pays, if you're changing deductibles, how much premium that the employee has to pay, those are all terms of the plan. And when those changes occur, you have to provide, again, communication to the participants, and that's known as a Summary of Material Modifications, or an SMM. The next bullet talks about SBCs, and we know that this requirement or disclosure requirement was introduced by the Affordable Care Act, and it discloses information to participants about the plan. Now, the most important thing that you need to remember on this slide is that all of these obligations that are required by a plan sponsor or employer is that an employee as a participant and also beneficiaries, they have the right to enforce these requirements. Now, how would it be enforced? Well, for one thing, they can come to you as the employer and say, hey, you're supposed to give me a plan document or a summary plan description. Can I have it? Or if they're not satisfied, they can always go to the Department of Labor and complain. So ERISA tells us, or mandates, that every employee welfare benefit plan must be established and maintained according to a written plan document. So as an employer, if you don't have a plan document, if you don't already have something in writing, you can't be sitting listening today and wipe your brow and say, phew, I don't have to worry about ERISA because I don't have anything in writing. Well, it's really to the contrary. And this is because as a plan administrator's failure or refusal to put a plan in writing, it's just merely a violation of ERISA, and it doesn't avoid any coverage of the plan by ERISA. So even if there is no document, and if an employee takes a plan, the legal entity plan to court, what the courts will do is they're going to look at the intent of the employer. Was there a reasonable expectation that benefits would be provided? What were the benefits? What were the practices of the employer? So they're really going to be looking at intent. Can someone ascertain that a benefit was going to be provided? You had a supervisor tell an employee, we have a great medical plan or a great vision plan. That employee thinks they're going to get medical or vision. Then they want to know what those benefits are. And if it was misrepresented, if it isn't corrected, then you actually could be creating an ERISA plan. Now, the other issue to be concerned about is exactly what do we mean by the ERISA plan? The actual plan is a legal entity. The legal entity or the plan, it can sue and it also can be sued in a court of law. So when we talk about our different benefits, medical, dental, vision, disability, those are all components of the plan. So we have a plan, it's a legal entity in itself, and then we have benefits that are provided through the plan. So we have an example. So here we have ABC Company, and they may have their ERISA plan that they call the ABC Company Employee Benefits Plan. That is the legal entity, and maybe that plan provides, again, medical, dental, vision, disability. Those are all the components. Now, I want to have a word of caution here, because you need to be careful. The ERISA plan could also include voluntary benefits, benefits that you have your employees paying for entirely on their own. And again, that's a discussion for some future webinars. Now, although the ERISA statute does not tell us exactly what format this written document has to be in, it does specifically reference what information it must contain. So for one thing, it has to have all the terms and conditions of the plan. You have to have a designation of our fiduciary. Every plan must have a named fiduciary. We have to have procedures for how are we going to establish and carry out the funding policy, and what kind of funding method are we going to have. Are we going to be self-insured Or are we going to be fully insured? Or are we going to be a combination of both of those? Also, we have to have descriptions of any procedures where the plan may say, we're going to allocate responsibility to the benefits manager or the HR director. So it specifically says who can go ahead and perform duties on behalf of the plan. We also want to look at the benefits. We're talking about benefits. We have to know what payments will be made by the plan. And also, again, how is it going to be funded? Are there going to be employer contributions and employee contributions, or just one or the other? So some other just general information that needs to be in there. Again, procedure for allocating the responsibility, amendment and termination procedure. If you want to go ahead and terminate a benefit, we don't want to provide vision anymore. How are we going to do that? Are we going to provide the notice? Does someone on our board of directors have to sign off on that? Or again, exactly how do we take care of that? So with that, Chuck is going to go ahead and talk to you about disclosure to participants.
Thank you, Frances. As you can see, the summary plan description is a very important document. This is where participants learn of their rights and obligations. In our research, we have found that a vast majority of employers of all sizes either don't have a summary plan description or have not updated their summary plan description and document in quite a while. And you know, that's obviously going to cause problems. One of the biggest issues or misconceptions that we've come across, and so it's important to understand that a benefit book is typically not a summary plan description. The insurance company booklet generally describes the relationship between the insurance company and the employer. But you need a document that describes the relationship between you and your employees and also meets the minimum standards of ERISA, as Frances was discussing. When you distribute an SPD, it's also important to know how to do it properly. We'll discuss penalties in a few minutes. And you can see the distribution required dates on the slide. It's important to follow those, and we'll discuss that a little bit later as well. It's also important to make updates to the SPD. As mentioned earlier, this is accomplished by providing what's known as a summary of material modifications within the time frame listed here. A shorter deadline may apply in some circumstances, depending upon the nature of the modification or change. If the change is a material reduction in group health benefits or services, the deadline for providing the SMM is 60 days after the change is adopted. This should not be confused with the 60-day advance notice requirement for summary of benefits and coverage, which we will also discuss coming up here. Frances?
Thanks, Chuck. So Chuck just mentioned, you know, when you have to go ahead and provide that, as we noted on the slides, when you have to distribute your SPD. But ERISA also tells employers who must receive the SPD. First and foremost, it must go to participants. It's those who are currently covered under the plan, either as an active employee or as a retiree. Something that you always have to keep in the back of your mind, participants also include COBRA qualified beneficiaries. So if you're updating that SPD or sending out a new SPD, you always have to remember to think, who's on COBRA? What employees terminated and elected COBRA? Because you also have to provide this information to them because, again, they are still considered a participant. Also, you have to provide it to anyone who may be receiving benefits under what's called a Qualified Medical Child Support Order. This is referred to as a QMSCO. And sometimes you may have an employee who is covering a child that doesn't live with them, so they're considered that alternate recipient, and they would also be eligible to go ahead and receive this type of document. Now, the one thing that you have to remember, that we talked about participants receiving the SPD. For a health and welfare ERISA plan, spouses and dependents are not required to automatically receive the SPD. So in other words, when you're distributing it to your current employees or retirees, you don't have to automatically give it to the spouse or a dependent. However, as a beneficiary, they have the right to come to you and request those documents at any time. So now that we've talked about, when we have to give it and how we have to give the SPD, let's just quickly talk about how we can go ahead and deliver these SPDs. The key issue here is that whatever way you decide to deliver it, that the employer has to make sure that the participant actually receives it. And it's always a good note that you should have some type of documentation of the method that you choose to distribute and then how you've executed that. Something as simple as printing off a computer sheet of all the participants that you're giving it to and putting a note on the bottom saying, we hand-delivered the SPD to these participants on this day. So some methods you can use, first-class mail is always good. We talk about insert in company publication. Well, not so much the SPD, but any other communications, an SMM, the SBC, you can also do that. Electronic delivery. In several slides, we're going to go ahead and really go into detail about electronic distribution at the work site. But for now, I just want you to recognize that just posting an SPD on your intranet site alone is going to be insufficient. And this is because you have to be able to track. You have to ensure that receipt. So you have to be able to track to see who received it. And unless you're doing that, then it's going to be considered insufficient. Also, if you're sending your SPDs out by email, you have to, again, be able to track. If someone's out of the office, then you can't say that they received it because they didn't open that email. On the next slide, we're going to be talking about the summary of benefits and coverage. Again, another disclosure requirement. Now, we know that the Affordable Care Act, it amended ERISA to include the requirement of this new disclosure to plan participants, and it's known as a summary of benefits and coverage, or we reference it as the SBC. What is key is that the Affordable Care Act also amended other laws such that all employers, not just private employers who are subject to ERISA, but also governmental employers and church employers also have to meet the SBC requirement. In a nutshell, the SBC, it started out to be a 4-page document, and it's probably expanded to at least 8 or 10 pages now, where it tells you about, again, the terms of the benefits, the deductibles, the co-pays. But it also includes a little glossary of terms, and it also gives examples of how the plan works. So for an employer that provides health care coverage on a fully insured basis, both the insurer and the employer are jointly responsible for providing the SBC to participants. Generally, the insurer is required to give the SBC to the employer, and then the employer goes ahead and distributes that to the participants. Now, this isn't to say that an insurer cannot automatically send it to a participant, because that's generally how it works, and they can't do that. It's just that you have to know as an employer, if the carrier has not provided that SBC, you can be liable or possibly liable for a violation. And violations for SBCs, the penalties are pretty hefty. They're $1,000 a day for not providing them. So just want to go ahead and make you aware of that. Also wanted to go ahead and address with you that we've been using the same SBCs now since 2012 when the requirement first came out. The Department of Labor, actually earlier in 2015, issued the requirement that new SBC templates are going to be available. However, the carriers for fully insured plans and for employers for self-insured plans, you will not have to start using them until your plan year that starts on or after January 1st of 2017. Another key issue to be to know about SBCs is that there is a requirement that every SBC must have 2 statements, and the statements must say that the plan either provides minimum value and that the plan is also minimum essential coverage. What the Department of Labor has provided is that if the insurer is not putting those statements on the SBC, then you as the employer is responsible in a separate little letter or a note or just a cover page to include those statements when you give the SBC to your participants. So now for a couple minutes, we're going to go ahead and talk about electronic distribution. And mainly we're going to go ahead and talk about when you distribute it at work. As we've already noted, that when you're providing, first of all, I want to go ahead and let you know that when we talk about electronic disclosure, this applies to any ERISA document that you have to give out. The SPD, the Summary of Material Modifications, also your SBC. We talked about a summary annual report if you're a larger group. So first of all, they can be done electronically. And in order to do it, they have to meet certain DOL requirements that we call safe harbors. And what a safe harbor is, if you follow these requirements, then you don't have to be concerned about the DOL trying to come after you and punish you, because you can say, I've done what you said I need to do. So when we're distributing electronic documents at work under ERISA, again, we just have to keep repeating. You have to ensure actual receipt. You just can't post it somewhere and hope and pray that they're going to go ahead and access it. The electronic materials have to meet the requirements. It has to have all the terms and any conditions in it. Also, you always have to let the participants know that if they want a paper version at any time, they can go ahead and request that, and it would be provided free of charge. And then another issue is that you also always have to inform the participants, and you have to take steps to ensure the confidentiality of any information that you're provided. So after this electronic distribution, another key thing when we're at work, you can only distribute documents electronically at work when computer access is an important or an integral part of a person's job. So if I'm sitting in my office working at my computer all day, that's pretty integral. I'm using my computer. You can electronically give me access to the documents. However, if I'm in a situation where I'm out driving a truck and never see a computer, or I might be working on an assembly line of some sort, and again, never see a computer, having that access is not integral to my job, so it cannot be electronically distributed to me. There's also some requirements that if you want to electronically distribute these documents outside of the workforce, the requirements are much more complicated. We don't want to go into them here. However, we at JRG, we have some outlines and documents that really discuss electronic disclosure and can outline all the steps that you have to take. So if you'd be interested in receiving them, please just contact your JRG representative. So the key thing about electronic distribution, especially at work, if you're in a situation, you can't just put a computer kiosk in a cafeteria room and let people access it, because again, the DOL is going to say it's not meeting the requirements. And now I'm going to turn it back to Chuck for some rights and penalties discussion.
Well, thanks, Frances. In our research, we found that two of the most prevalent reasons why an employee is selected for a Department of Labor audit is either a disgruntled employee complains or a systematic review is underway. Both situations exist today with the Department of Labor. Let's talk about your disgruntled employee. All they have to do is contact the DOL. And one common area that complaint they hear is that I asked for a summary plan description and didn't receive it, or got something that didn't look like an SPD, maybe a booklet or have you. And so it's very, very important for employers to respond promptly to individual requests for any document, particularly a summary plan description. You have 30 days to respond, and as you can see, you can require the request to be in writing. Penalties can range from $110 a day for failure to furnish an SPD within 30 days to up to $1,100 per day for each day an administrator fails or refuses to file a complete Form 5500. So I know that there are several great examples of large penalties that have been assessed recently, and I'll let Frances tell you all about that.
Yeah, thanks, Chuck. Well, the cases that we're going to be talking about today, just coincidentally, are talking about electronic delivery and also actually delivery of the SPD. And two interesting cases, again, that I came across, and the first one we're talking about involves electronic delivery. And this case involved an employee who was covered by an employer's life insurance benefit plan. And unfortunately, the employee became disabled, they stopped working, and consequently, they stopped paying the life insurance premium. Now the policy, like most life insurance policies have this waiver of premium for disability. But the participant never applied for the waiver, and especially not within the required time frame that was stated in the summary plan description. So unfortunately, this employee passed away, and the beneficiary for the life insurance filed a claim for the benefit. And what happened is, naturally, the insurer denied the claim, saying that there was no waiver of premium and that the policy was no longer in force, so that no benefit was going to be paid. Well, what the beneficiary did is that they claimed, they sued, actually, the plan, claiming that the employer never communicated the requirement to apply for a premium waiver. And the employer claimed the requirement was in the SPD. They did something correct there, which was posted on its intranet. And what the court said is that ERISA requires that the employer furnish the SPD. The participant has to actually receive it, not just make it available to the participant. And just posting it did not meet those requirements. So in this case, the court ruled in favor of the beneficiary. So the beneficiary did receive that life insurance benefit. The case didn't discuss whether the employer had to pay it or if the insurer paid it. But also what's most important is the beneficiary was able to also recoup any attorney fees and costs that they had incurred in pursuing this claim. The second case that I want to go ahead and talk about, and this case just actually was resolved within the last 8 weeks. It was settled as of September 15th, and it also involves a life insurance claim. And this is where a beneficiary sued for denied benefit. And in the process, what they did is they requested from the employer the summary plan description that was describing the benefits. And they actually first requested this document back in 2012. So after several requests, finally in 2013, the employer provided the beneficiary with a copy of the insurance policy, not the summary plan description, the insurance policy. So the beneficiary, evidently having spoken to an attorney, kept making requests for the plan document. And finally, the employer provided this in 2014. Now, once this case got to the court and the judge reviewed it, based on the terms of the plan, the court upheld the denial of the benefit. It said, yes, it didn't meet the requirements. The beneficiary doesn't get the life proceeds. However, what the court did in this case, it still awarded the beneficiary over $74,000 because it basically said, this beneficiary, this person who had the right to these documents, kept asking for them and asking for them. And the plan administrator, the employer, wasn't responsive, especially within the 30-day requirement that it had to meet. So what the court did is it actually fined them for $110 per day. And remember, this case was going on for over 2 years, and that's where we get to the $74,000 amount. So in this case, the beneficiary didn't win the actual claim, but they did get those penalties. So it probably was a win situation for that plaintiff. So these cases, they really serve as reminders for us that plan documents must be provided to participants and beneficiaries in a certain manner and in certain time frames, or penalties can be collected.
Well, thank you, Frances. That concludes our presentation this morning on ERISA and focusing on disclosure. We're happy to take any questions that you wish to ask. Please type them in the area provided, send them to us, and we can respond. And of course, we know that if there are no questions, that means Francis and I did such a stunningly, unbelievably great job that everyone understands ERISA and what they need to look at their own business practice to make sure that you're in compliance. Obviously, at JRG, compliance is becoming a bigger and bigger part of our services, and we are happy to assist in that area. All right. Well, we appreciate your time this morning. Please note that on November 11th, there's another webinar on individual open enrollment. Obviously, talking about the marketplaces. Francis and I will be back on the 12th and the 17th, and we look forward to having you participate in those. Any feedback you'd like to give? I actually talked long enough. We have a question.
The first question, is there a minimum number of employees before requirements are effective?
That's actually a great question, because I mentioned that under ERISA, when you have to file Form 5500, the requirement is that you have to have 100 participants in the plan. However, that's not the overall requirement for ERISA. ERISA applies to any benefit plan that employer sponsors as long as it covers at least one employee. So you could be a very small employer. You may only have 1 or 2 employees, and you would still be subject to ERISA, and you would be subject to these requirements that we talked about, requirement to do plan documents and SPDs and SMMs. So great question, and again, the requirement is as long as you're, as an employer, are providing the benefits that Chuck discussed that are subject to ERISA, and you have at least providing them to 1 employee, you would be subject to ERISA.
And it's worth noting that it's the Department of Labor's intention to audit every group plan for the compliance with the Affordable Care Act. And gosh, while they're there, they're also going to look at ERISA, because that's what they've been doing, compliance for 40 years. So on both sides, you need to look at both laws. Any other questions? All right, well, we certainly thank you all for your time this morning. Appreciate your feedback, and look forward to the next webinar coming up.
Yep, thanks so much, and everyone have a good day today.
Bye-bye.